Nick Maruchak joins us from MKI Legal. G'day, Nick. Good to see you.
G'day, Bowie. How you doing?
Very well, thank you. Nick, it's busy in here. Nick, we have talked a fair bit over the last couple of months about people contesting wills.
Yep.
And you've got some advice. You've got a colleague in the industry who has some advice for our listeners.
That's right. So a friend of mine, Aaron Kitson, he's a lawyer at Lewis Kitson Lawyers in Applecross. So Aaron Kitson gave me some tips to share with the listeners about things you can do to reduce the chances of someone succeeding when they challenge your will. So you can't stop someone challenging a will, but you can make it harder for them. So this really applies to the immediate family. Not everyone can challenge the will, such as siblings and brothers and sisters can't. It's really spouse, children, those kind of relationships, and in some cases grandchildren, and in some cases stepchildren as well. So these are some stuff you can do to make it harder. So when someone challenges a will, the first thing they go after is your estate. So the definition of your estate is assets you own personally at the time of your death, right? So basically assets in your own name. If something is not inside your estate, then the court at the moment doesn't have the power to attack it. So the first kind of tips are different ways to put assets outside your estate. So one way is put it into super. So if you, they can't go after the assets in your super. So if you do something, if you make a binding death nomination in your super fund, that forces the trustee of your super fund to pay out to who you want it. So it doesn't go on the will, it's outside the challenge.
Okay.
Next tip is to create a trust while you're alive, because again, if you create a trust properly and the assets in the trust are not part of your estate, the court cannot actually challenge it, right? Because in some states, they do have laws that were passed where they can claw back assets put into a trust, but we don't have these laws. So if you get some advice on that's a way to mitigate it. The trust will be taken into account, but so for example, like the court will say, all right, you have a trust, we can't touch it, but we might give more assets to people who've missed out from the trust. So it's still considered, it's not bulletproof, but it does make it harder. Another way is restructure your assets. So if you own a house as joint tenants, right, with someone, that can't be challenged. That joint tenancy, two people own a house as joint tenancy, which is very common between husband and wife. When someone dies, the other person will automatically inherit everything. So that's a good way of just avoiding the courts examining it. Another way is to create a statutory declaration. Put it next to your will. Don't attach it to your will because there could be problems during probate. But just explain why you left that person out. Give your details. Now, this context will be helpful for the court when they're making a decision on whether the person succeeds or not. It's not decisive.
So to I'm interrupting, I know, but
yes, sir, please.
So look at your superannuation setup because that cannot be examined.
Yep.
Consider getting a trust together because that cannot be examined either. Make that separate.
Yep.
The third one.
So set up your assets in a way that takes advantage of the joint tenancy, right?
Joint tenancy, yep.
Yep, especially with houses and stuff and bank accounts.
And the fourth one is a stat deck declaring why you are leaving someone out of
the will,
the considerations and out of the will. Wow, that's amazing.
Yeah. And don't attach the stat deck to the will. Keep it outside the will because if there's anything like a paperclip mark on the will, the court will examine that and go, is there something missing? So with the stat deck, you only really pull it out if someone challenges the will. If no one challenges, you don't pull it out. No one ever reads it because I'm sure there's going to be some unpleasant things in there. Yeah,
if you'd like to call Nick Maruchak, you can, 133 882. Your colleague's name again?
Yep, so Aaron Kitson from Lewis Kitson Lawyers. They're based in Applecross. They do this kind of work all the time, and they can help you if you think there's a challenge or to make.
How many people do you think, and I don't know if you have these metrics with you, Nick, but how many people just go through a standard online will document? Because I know you often work in the area of IT and portals and making legal information easy to access, don't you?
Yeah, that's right. And I think online wills are fine. There's some good providers out there, right? So if you find a good reputable provider, use them because they can be cost effective and get the job done. The only time you want to really think about seeing a lawyer is, say, if there is a challenge to a will, but if you're basically leaving everything to your husband or wife or partner and kids, there's not going to be a challenge there. You're fine. But if you want to leave the kids out, if you're separated or there's something more complicated, then probably see a lawyer for that.
Yep.
And if you also want to see a lawyer for creating something called a testamentary trust, which is basically a trust that is set up when you die, and that can be useful for minimizing tax. So if you've got a couple of kids, you can set up a trust for each of them, and then that trust can operate for 80 years, and they can share that assets with their kids and stuff like that. So more complicated things like that are also helpful to see a lawyer for.
Thanks, Nick. G'day, Kim.
G'day, Nick, and Simon.
Thank you.
I was listening to what you were saying about wills, and I remember from equity and trust at uni many decades ago. But just with regards to the timings of those techniques, is it still the case that if the timings are very close to the person passing, that the court can undo them if they see them as you creating them with a specific reason to exclude somebody, essentially trying to legislate the court out of its jurisdiction?
Yeah, so that great question. So if you are going to implement these techniques, I do recommend you speak to a lawyer, because sometimes, especially with a trust, there are pitfalls and tripwires that you can come up against. So, for example, if the trust is almost like a sham arrangement, then there could be some grounds to attack it. If you give money to the trust, there could be like loan arrangements in place that could be attacked and clawed back. So there is some way in equity to attack the trust. That's why it's better to do it with a lawyer and to get advice on it. But in the eastern states, in Sydney, they do have a law where if assets are put into a trust before death, they can be clawed back. So that's a law that WA actually doesn't have. Eastern states does. So in the future, maybe we will get that law. But at the moment, my understanding is that these clawback provisions don't apply here. They apply in specifically in other states. But it's a risk it could happen in the future.
Is that all right, Kim?
Yes, thank you. I think, Nick, isn't the term you need to come into equity with clean hands? That's about my extent of my memory of it.
Yeah, look, that's a maxim, right? It's an equitable maxim. Like it's like a general statement of the court. It's not actually like a legal principle. It's just like you've got to come in with clean hands if you want to seek an equitable remedy, right? Which means that if you yourself have engaged in conduct that's not above board, then the court will take that into account to make the decision.
Very interesting. Thanks, Kim. With clean hands. Cheers, mate. Thank you. G'day, Matthew.
Hi. Nick, I was just wondering, you made a comment about don't attach things to your will and paperclip marks and all that sort of stuff. I just had a question. If your will's got more than one page to it, what's the best way to bind it or connect it all together?
Oh, yeah, so that's a great question. The reason for the paperclip mark is because the court actually sits in chambers and examines the will. So they go through it and they look to make sure it's a complete document. So lawyers often will have these spiral bounds, so that it will just bind in a spiral. That's a clear way that shows that it's a complete document. Have other ways. Make sure you number the pages from. That's very clear to make it sure it's complete. But also a staple gets the job done. So yeah, these are some. There's nothing wrong with a staple as long as it's. As long as it doesn't appear that the staple's been tampered with.
Oh, that's amazing. I had no idea. Al, stay there, mate. We'll come back and take your call in just a moment. Thanks, everyone. Thanks, Kim. Thanks, Matthew, for phoning in. Any generic or general legal questions, Nick Maruchak is here to answer your queries from MKI Legal. Coming up to 10:45. Thanks for listening. Phone lines are open, 133 882. Spoke to a couple of people from the Sovereign People's Assembly during the week.
Mm-hmm.
A couple of West Australians who would prefer to live by their own set of rules and laws. They did hark back and said, look, originally it came from the days of Henry VIII and a lot of the frameworks we operate on are illegal. And we all heard them out and our listeners said some fairly intelligent things about it all. But there are people, you've seen the Four Corners episode yourself, there are people who make the choice to try and live outside of it. What do you say about the sovereign citizen movement? And these guys have got 300 members here in WA.
Yeah, so it's people who are discontent about the law, and these people have argued that our legal system is not valid. They pick and choose which laws apply. They make all sort of arguments that extends back to the Magna Carta. The court has dealt with all these arguments. There's been decisions done where they've addressed them, and it's basically we have a very valid legal system. The Constitution applies, and what happens to a lot of these people, unfortunately, is they push it so hard and they just get deeper. It's a spiral effect where they don't recognise the jurisdiction of the court or the police, and they just get done, and some of them end up in jail and also lose a lot of money, because if you don't follow court orders and then the sheriff can come in and take your assets. So some of them listen to the wrong people, take the wrong advice, and end up financially devastated.
Well, they seem like decent enough people, but it was not an easy interview, let me tell you. 133 882 if you'd like to speak to Nick Maruchak today. Hi, Al.
G'day, guys. For an executor, so I signed over an agreement with a lawyer for my sister to act as the executor, even though there was no will. But there was a will. So now, so the question is, when it comes to executor, when I signed that over, she acted as executor and just gave herself everything.
Okay.
So, and I got no paperwork, no, like pro rata. I had to fight for that. And every time I asked for something, it was, it is what it is. What is it with the, when I signed over without a will, but there was a will apparently, I've got a copy of it. The power, when you sign over power of executive, what, can they do that? Can they just be executive and just give themselves everything?
No. So there's two things. If someone dies with a will, the executor is picked in the will, and it's the person who's picked in the will that will act as the executor. If someone dies without a will, then you can pick an executor. It's called an administrator. It's when you die without a will, your estate is divided according to the law, right? So it sets all these different scenarios. So if you're entitled to a piece of the estate, you can act as the executor if there is no will. So it sounds like in your situation, they probably thought there wasn't a will and they applied for letters of administration, right? And then they probably found a will later. So that complicates the situation. If that happens, then they have to bring that will to the court's attention, and that previous letters of administration has to be revoked. So it's a bit of a complex situation. And also the answer to your question is no, an executor or administrator can't give them everything. They have special duties to follow where they have to act for in the best interest of the estate and for the beneficiaries. And if they start giving everything to themselves, they can be removed. So it sounds like your situation is a bit complex. I'm happy to kind of just get me and my team give you a call, get some more information from you and try and give you some tips, because it doesn't quite sound like things are going according to law there.
Oh, I'll put you back to Sophie and to Kira, mate, and we'll see if we can... Thank you, Nick. Thank you for the offer. We'll see if we can get that sorted for you. Hi, Brian.
Oh, g'day, mate. What's happened? My brother lived with a woman 48 years ago. Now, to get a loan to buy this property, they went to the bank and she went as his wife, which they weren't. But they only lasted together 6 months. Now, he's getting ladies in his 80s, but it's in joint tenant. So even though she's contributed nothing in that 6 months they were together and gone, but her name's on the property. So if he dies, it goes straight to her. Can that be challenged?
I would say that you want to take steps to sever the tenancy. So you've identified there a real big risk here, right? The thing with joint tenants is they get it automatically. So he should be seeing a lawyer, and he should be taking steps to sever the tenancy, right? Convert it from joint tenants to tenants in common. So that's important. He does that. That process is also quite difficult, right? In other states, you can just file something with Landgate and change it. Here, it's more complex. There's a process involved. But I would recommend that he take steps because, yes, if he dies, that lady that's on the title from 40 years ago could get his entire property. So, yeah, that's something that I would really encourage your friend or that brother to do it. Yeah, absolutely.
But okay, Brian?
So he's had a cost of $100,000, which is a lot of money.
For what?
For a lawyer. Starting at $100,000 to sort this out.
Is that no? That's too. That doesn't sound appropriate. That sounds a bit expensive. So,
I reckon there's a lot of work. So.
Well, he might have to make an application to the Supreme Court to do something. But $100,000 sounds excessive, and I think you should get some other quotes around as well. And but you should action this, because I can also, if you like, we can get in touch with you as well, and I'll just give you a bit more information about this. But yeah. The severing a tenancy in WAs should be an easier process, and it's not, and it just puts you in a difficult position here. So,
yep. Brian, I'll put you back to Soph. I'll put you back to Kira, and we'll see if we again. Thank you for the offer. Mr. Maruchak. G'day, Matthew.
Yeah, g'day. How you going?
Good, mate.
Good. I divorced about 4 years ago. Financial settlement went through early this year in February. Part of that, she gets to keep the house. Now, within 30 days of it going through, she was supposed to have the loan put over into her name. It's still not been done, and I'm in the process now trying to actually go and purchase a house for myself. But I can't until my name's off that loan. So I'm wondering, can I possibly force sale of the house now if she's not going to have it put into her name and then request some of the profit?
Yeah, so when you did this deal, did you have something called consent orders issued by the court?
Yes, they were, yes.
Right. So in the consent orders, does it say anything about what happens if she doesn't refinance, or is there a provision there where the property is sold?
No, there wasn't. There was an original offer of actually selling the house. She'd keep the first $100,000 of profit. Everything after that was split 50-50. Whether that went into the final consent, I'm not sure, to be honest.
Yeah. So because what normally happens, right, is when you get these consent orders, you have a time frame, and then it'll say if you don't refinance within a certain amount of time, then the property is sold, right? But if there is no provision for selling the property in your consent orders, then what you have to do is you have to potentially make an application for a contravention. So she contravened the orders, and then the court will make orders to sell the property, right? Because ideally, in your case, would you want the property sold and then the equity be distributed to you or your share?
Well, yeah, it'd make my life a lot easier moving forward to get myself into the property market again. Way it's all been going over the last 12, 18 months, yeah.
Yeah, so Matthew, you have to make an application to the court to do that. I've seen this situation a fair few times. I'm happy to grab your details. I can send you an email with all your different options and explain this more for you as well. But yeah, it's you have to take steps now to enforce it with the family court.
Thanks, Matthew. I'll put you back to my team. Thank you, Nick. Thank you for today. Thanks for your thoughts, expertise, and thank you for following up with our listeners. If you have any updates, please let us know. We see you next week.
Thank you, Broy.
Cheers. Got on your mate, Nick Maruchak. It is 3 minutes to 11.